Hello everyone, my name is Nicholas Olson. I'm a barrister here at Level 22 Chambers specialising in media law. This is a seminar about the Defamation Amendment Bill 2020 of New South Wales. It's passed both Houses of Parliament and it received the Royal Assent on the 11th of August 2020, but it hasn't yet come into effect. And so this is a good time to consider what impact the changes introduced by the Amendment Bill are likely to have on questions of who can sue for defamation and the processes surrounding the commencement of proceedings. The Amendment Bill makes some quite significant changes to these aspects of defamation practice. And these are changes that practitioners who act for plaintiffs in particular will need to be mindful of in relation to cases involving any defamatory matter published after the commencement of the amendments. So what I want to do today is to highlight some of these aspects of the Amendment Bill and to point out some of the pitfalls and suggest some strategies for practitioners who act for plaintiffs. And I'm going to cover three main areas of the amendments. That is, the amendments relating to the rights of corporations to sue for defamation, the notion of serious harm as an element of the cause of action, and the pre-litigation procedures, particularly in relation to concerns notices. I don't want to get into the changes made by the amendments to the defences, and some of the other speakers in Level 22's CPD series on the amendments will cover those aspects of the legislation. So turning to the first aspect, anyone who acts in defamation knows that as a general rule, a corporation has no cause of action for defamation. That's the effect of Section 9 of the Defamation Act 2005. That is, unless the corporation is an excluded corporation. And a corporation may be an excluded corporation under Section 9.2 of the Act if A, it's a not-for-profit corporation, or B, if it employs fewer than 10 people and isn't related to any other company. And as much as it might seem to be a conveniently simple proposition that a corporation can't sue for defamation, the exclusions in subsection 2 introduce some potentially substantial areas of uncertainty. The first is, what does it mean for the purposes of subsection 2 to say that a company employs fewer than 10 people? The question's not as simple as it sounds. In Born Brands and Nine Network Australia, which is a 2014 decision in the Court of Appeal, Justice Baston held that the use of the expression employees in the context of that section is consistent only with the use of the verb employs as referring to a person having a contract of employment. So those observations, they were obiter in Born Brands, but it is the leading authority on the section. They seem to confine it to employees in the strict sense, that is, people who are engaged under a contract that says employment contract on the first page. But one difficulty with that approach is that that's not what the concept of an employee means in industrial law. As a matter of industrial law, the existence of an employment relationship is defined by the actual practices and systems of work. We all know that the High Court decision in Olson Varbu Proprietary Limited is authority for that proposition. And so in debates about whether a company employs fewer than 10 people for the purposes of Section 9, some quite difficult factual issues may arise as to the exact nature of the company's relationship with its workers, and the use of the potentially vague word employees in Section 9.2 doesn't necessarily provide very much guidance. This is an area where the Amendment Act provides real clarity, and it also potentially expands, I should say definitely expands, the meaning of the concept of employment. The Amendment Act introduces a subsection 6 in Section 9, which defines an employee as any individual, whether or not an independent contractor, who is engaged in the day-to-day operations of the company other than as a volunteer and is subject to the control and direction of the company. So that covers a very wide field of people, not just employees in the strict sense, not just people who would, as a matter of law, be deemed to be employees under authorities such as Olson, but also independent contractors in the true sense of the word, anyone other than a volunteer, in fact, who is engaged in the operations of the corporation and is subject to its control. The Amendment Act also broadens the other aspect of the exclusion provisions in Section 9.2, which is that the corporation must not be related to any other company. Related entity under the current legislation is defined in terms of Section 50 of the Corporations Act, and the question is effectively whether the company has any holding company or subsidiaries. But the Amendment Act does away with that and introduces the new concept of an associated entity, which is potentially much broader, because the Amendment Act gives this concept of associated entity the same meaning as Section 50 AAA of the Corporations Act, which defines the circumstances in which one entity has control over another. And the concept of control, in a corporate law sense, is potentially much broader than the simple question of whether one company is a holding company or subsidiary of another. So I can illustrate what impact these amendments may have by reference to a case that I'm currently involved in. I am, as of this moment, in fact, appearing in a trial in the district court for a defendant who is being sued by a company. The company is a travel agency, and it claims that it has only 5 employees, but it operates a call centre in India where potentially as many as 40 people work on behalf of the company, and they're held out to the world as employees. They have email addresses for the company. The sign-off box on their email indicates that they're employees, and the company refers to them as employees in its external branding. But in the context of this trial, it argues that they're not. They're in fact independent contractors. In the context of this trial, the current state of the legislation requires the court to embark on an extensive factual investigation of the nature of the work done by these people, the contractual arrangements in place, who pays them, who pays the superannuation, who's responsible for the workers' compensation insurance, all those kinds of considerations. But if this case were being conducted under the amended legislation, it would be much simpler. We would be in a position to submit that they're engaged in the day-to-day operations of the plaintiff. They're subject to its direction and control. They fall within Section 9.2 of the legislation, and the company is therefore not an excluded corporation. What this shows in summary, is that the effect of the amendments is to shift attention away from the precise legal characterisation of a company's structure and its relationship with its workers, and to focus attention instead on the practical reality of those arrangements. So practitioners who are being asked to advise about whether a corporate client can sue for defamation will need to be mindful of this broader, more practical aspect to the amended legislation. It won't just be enough to ask a corporate client how many employees it has. It won't just be enough for the purposes of the related entity inquiry to analyse the shareholdings. Practitioners will need to take a broader view, and they will need to ask themselves whether the substantive reality of the company's working practices and arrangements is consistent with the exclusions in Section 9, subsection 2. So I want to look now at the serious harm aspect of the amended legislation. This was possibly one of the more contentious aspects of the amendment bill. What the amendment bill has done is to abolish Section 33, which is the defence of triviality, was the defence of triviality, and to replace it with a new subsection, a new section, 10 capital A, which provides instead that it is an element of the cause of action that the publication of the defamatory matter has caused or is likely to cause serious harm to the reputation of the person. And in the context of a corporate plaintiff, serious harm means serious financial loss. Section 10A also provides a scheme in which the notion of serious harm may be determined as a preliminary question, and it also provides judicial officers with the power to determine that preliminary question on the papers without hearing from the parties. Now, these changes mirror changes that were introduced into English defamation law by Section 1 of the Defamation Act 2013. Other presenters in this series will have much more to say about the English position, but it's necessary to say something about it in this context, because given that Section 10A of our Amendment Act was effectively introduced in imitation of the English legislation, it is likely that New South Wales courts' understanding of what serious harm means will be shaped by the English authorities. The English legislation itself was enacted against the background of a developing common law recognition that there was a threshold of seriousness that was an element of the very definition of whether something is defamatory. That's exemplified by the cases of Jamil and Dow Jones and Thornton and Telegraph Media Group. And in La Show and Independent Print, the Supreme Court held that the English legislation was to be construed in light of those common law authorities. The case of Thornton in particular is often cited in discussions of what serious harm means. That was a case about an author, the author of a book, who sued over an imputation that she had engaged in a practice known as copy approval, which is apparently highly disreputable within the world of journalism, and that she'd thereby shown herself to be untrustworthy and lacking in integrity. The trial judge held that that wasn't capable of imputing to Dr. Thornton anything which, in ordinary language, could be regarded as reprehensible, applying the standards of society generally, and that any defamatory meaning fell below the threshold of seriousness. Now, the imputations in Thornton seem to have been pleaded in the natural and ordinary meaning of the matter complained of. It doesn't appear from the report that there was any true innuendo pleaded. So what that points to is one potential consideration for practitioners who are acting for plaintiffs in a case where the concept of serious harm may be contentious. It is possible, in principle, that something may not be likely to cause serious harm in some circles, but in a more specific context, a more specific social or professional context, the possibility of harm may be much more real. And so practitioners who are acting for plaintiffs in cases where the element of serious harm may be contentious should give consideration to whether imputations should be pleaded as true innuendos, because the pleading of the imputation as a true innuendo rather than in the natural and ordinary meaning will focus attention on its effect within a particular sector of society, a particular class of recipients, rather than the world at large. And that in turn may play into the inquiry about whether serious harm is likely to be caused by the publication. Now, as I said, Section 10 capital A appears to envisage that in many cases the serious harm element may be determined as a preliminary question. That the legislation allows that to occur on the application of a party or on the court's own motion. And it also permits the court, as I said, to determine whether there has been or is likely to be serious harm on the pleadings and without hearing evidence. If that is ever raised as a possibility in a proceeding, that is something that a practitioner acting for a plaintiff would need to resist. Particulars of serious harm will need to be given under the amended legislation when pleading a cause of action for defamation, but particulars aren't evidence. And the particularisation of the serious harm element may not capture the full force of the evidence that would ultimately be led under those particulars. So if this issue is raised as a preliminary question, the court does have a duty to hear the parties and has a duty to accord procedural fairness. And my suggestion would be that any plaintiff faced with an application to summarily dismiss proceedings for want of satisfying the serious harm element should seek to have the matter heard and should seek the opportunity to adduce evidence on the question, because the actual hearing of the evidence on the question of harm may put a quite different complexion on the allegation than what simply appears from the dry particulars. And as a matter of practicality, I suggest that it would be quite unlikely that a court would shut a plaintiff out from adducing evidence on this issue if the plaintiff sought to do so because of the procedural fairness implications of taking that course. The other thing that needs to be borne in mind when considering summary dismissal is that any application for summary dismissal engages those well-known principles from the cases such as General Steel. The focus, as Justice McColl said in Corby and Alan Unwin, has to be on the fact that to summarily dismiss or strike out a case deprives the plaintiff of the opportunity to have his or her case heard on the merits. And there's nothing in Section 10 capital A which, in my view, would be construed as abrogating those principles. They're fundamental to procedural fairness. Plaintiff's pleaded case has to be taken at its highest. any available inferences favourable to the plaintiff must be drawn by the court on such an application, and a proceeding should only be summarily dismissed if it's clear that it has no reasonable prospects of success. So, although the amended legislation seems to contemplate that the determination of this issue as a separate question will be a regular occurrence, or that it may occur in many cases, I would suggest that there are likely to be relatively few cases in which it would be appropriate to summarily dismiss a plaintiff's case on this basis. Now, there's one particular aspect of the serious harm threshold which does not appear to have been considered in the drafting of the legislation, and that is what effect the introduction of this element will have on the limitation period. Because pursuant to Section 14B of the Limitation Act, the 12-month limitation period runs from the date of publication of the matter complained of. That's, of course, consistent with the fact that at common law, that's when the cause of action crystallises, at the moment of publication in comprehensible form to a third party. But Section 10A upsets that by introducing serious harm as an element of the cause of action. Arguably, on one view, the cause of action now does not crystallise until such time as serious harm has been incurred. So what happens if it only becomes apparent more than 12 months after the date of publication that the matter complained of has caused or is likely to cause serious harm? That may not be a problem in many cases, but it's not all that difficult to envisage a situation in which something is published online and perhaps doesn't attract very much attention for a certain period of time, only to later go viral, for instance. In La Chaux and Independent Print, the UK Supreme Court noted that this aspect of the legislation just doesn't appear to have received any consideration from the drafters. The Supreme Court suggested in that case that subsequent events will generally be evidence of the likelihood that harm will occur. But at least in the Australian procedural context, that's not a particularly satisfactory explanation or solution, because when a plaintiff files a statement of claim, his or her solicitor, of course, has a professional duty to certify at the time of filing that the statement of claim has reasonable prospects of success. So it would be arguably improper for a plaintiff to rely on events that occurred after the commencement of proceedings to retrospectively justify an allegation that, as at the time of pleading, the matter had caused or was likely to cause serious harm. The upshot, most likely, is that a plaintiff's inability to prove that serious harm has occurred or is likely to occur within 12 months of the date of publication will be a circumstance that justifies the extension of the limitation period. And in that respect, it's worth noting that the Amendment Act does significantly liberalise the grounds on which a court can grant an extension of the limitation period in a defamation case. The Amendment Act amends Section 56 of the Limitation Act to provide that a court may extend the limitation period for up to 3 years running from the date of publication if the plaintiff satisfies the court that it is just and reasonable to allow an action to proceed, which is much broader than the existing form of Section 56. So in practical terms, the serious harm threshold, to the extent that the serious harm threshold poses any difficulty in relation to the limitation period, it's fixed by the broader ability to apply for an extension. But it's somewhat regrettable that that potential impact of the introduction of a new element of the cause of action wasn't considered at the time of drafting the amended legislation. The third major aspect of the procedural amendments that I wanted to discuss relates to concerns notices and offers to make amends. The Amendment Act introduces a new Section 12 capital A which specifies in detail the content requirements of a concerns notice. The changes probably largely in accordance with existing practice, except that it should be noted that the aggrieved person has to specify the imputations of concern, which is already an aspect of the of current practice, and to inform the publisher of what the aggrieved person considers to be the serious harm that has been caused or is likely to be caused by the publication. And if it's a corporation, to particularise the financial loss. Now, the need to specify serious harm or to particularise serious financial loss prior to issuing a concerns notice means that the amount of the detail in which practitioners need to take instructions prior to issuing concerns notices will be greater under the amended legislation, and much more consideration will need to be given to the research that goes into preparing a concerns notice and the content of the concerns notice prior to issuing it. That's all the more so because of Section 12 capital B of the amended Act. Section 12 capital B provides that a defamation proceeding cannot be commenced unless a concerns notice has been issued, but in particular, that proceedings can't be commenced unless the imputations to be relied on by the person in the proposed proceedings were particularised in the concerns notice. And the period in which to make an offer to make amends also needs to have elapsed. Now, the requirement that the provision barring a prospective plaintiff from commencing proceedings unless the imputations were in the concerns notice, on one construction, shuts a plaintiff out from relying on any imputation in subsequent proceedings that wasn't particularised way back at the commencement of the proceedings in the concerns notice. If that understanding of the legislation is correct, the care that a practitioner needs to take in drafting a concerns notice is now significant. On one view, as much thought now needs to be given to the particularisation of imputations in a concerns notice as you would put into a statement of claim. And practitioners would be very well advised, this is perhaps a self-serving observation coming from a junior barrister, but practitioners would be very well advised to brief counsel at the outset to settle the concerns notice. And if you would brief senior counsel to settle your statement of claim, you might consider briefing senior counsel to settle the concerns notice too. The other option that a practitioner could take would be to throw everything but the kitchen sink into the concerns notice, put every conceivable imputation in. That, I would suggest, is not a strategy which is consistent with the purpose of a concerns notice. If you particularise every conceivable imputation, whether you intend to rely on it or not, you're not really giving the other side notice of what you consider to be of concern in the matter complained of. But this kind of care needs to be taken to avoid a plaintiff being shut out from relying on a potentially significant and crucial imputation later in the proceedings. What all of that is likely to mean is that the cost of drafting a concerns notice, taking into account the care that needs to be taken in settling the imputations and the research that needs to be done to properly particularise serious harm, those costs will be significantly higher. And it's an unfortunate aspect of the amendments that those higher costs will be passed on to defendants as well, because if a defendant wishes to make an offer to make amends under section 15(1)(f) of the Act, they also have to offer to pay the expenses reasonably incurred by the prospective plaintiff. One queries whether those high costs may operate as a disincentive to defendants to make offers to make amends. So the obvious question that arises is, what can a practitioner do if he or she forgot to particularise a key imputation in the concerns notice? In terms, section 12(b) bars the plaintiff from commencing proceedings unless the imputations to be relied on were particularised in the concerns notice. But it doesn't otherwise preclude the plaintiff, having commenced, from relying on imputations not particularised. And in particular, there's nothing in the Amendment Act which appears to restrict a court's ability to give a plaintiff leave to amend the statement of claim after the commencement of proceedings to introduce an imputation which wasn't in the concerns notice. So a practitioner who realises after doing the concerns notice that he or she has forgotten a key imputation should, I would suggest, commence proceedings pleading only those imputations which were particularised in the concerns notice, and then immediately, the first opportunity, make an application for leave to amend the statement of claim to include the omitted imputation. Now, the first time that somebody does this, there's likely to be an argument about whether that procedure is permitted under the amended legislation. That's a question of construction. Even if the strategy that I've proposed is permitted, courts may well regard the fact that the imputation wasn't in the concerns notice as a matter that's relevant to the grant of leave. But of course, if the application is made as soon as possible, the defendant probably can't demonstrate any prejudice. The significant thing about section 12(b) is that it really takes away a lot of flexibility from prospective plaintiffs. You need to have your ducks in a row when you settle the concerns notice. It won't be adequate anymore under the amended legislation to get a concerns notice out quickly, shortly before the limitation period expires, and just put any imputations in the concerns notice and then settle the statement of claim later. A great deal of care needs to be taken with them, and that will require advice, and that will require substantial instructions. So those are the main procedural aspects of the amendments which are likely to affect decisions about who can sue for defamation and the procedures that they need to follow in order to commence proceedings. As with any substantial amendments, the early days of the operation of these amendments will involve a deal of uncertainty about what is or isn't allowed in terms of procedure and how the amendments are to be construed, and all of that all of that reinforces the need for advice on these issues. Level 22 has a number of experienced counsel who specialise in defamation legislation and defamation litigation, and we'd be happy to assist with any such cases. That's it, Jackie. Oh. Happy to take any questions. Somebody's asked me whether the introduction of the serious harm threshold will have a chilling effect on minor claims. I think the difficulty with that is that people have different ideas about what counts as a minor claim. I'm currently briefed in a case, which some of you may have read about in the Sydney Morning Herald, involving a cavoodle who's an Instagram star who was allegedly stolen. On one view, many people might consider that, in the way that I've described it, to be a minor case, but anticipate that the evidence in that case will be that the plaintiff received death threats as a result of the publication of the matter complained of. It's obviously the purpose of the amendment to discourage minor claims to be brought. But no, I mean, I would suggest that nobody commences proceedings thinking that their claim is a minor claim. And as I suggested when I went through that part of the paper, particulars often don't capture what the full effect of the evidence is going to be, and it may not really be possible to appreciate how serious the harm is until one has heard the evidence. So I think certainly there will be cases that fall foul of the serious harm threshold and that are excluded and rightly excluded under the amended legislation. But I personally have some doubt about whether the effect of it will be as radical as some people appear to think it might be. Still have time for some more questions if anyone else has anything they'd like to ask. No? All right, well, thank you, everyone. I think that concludes it.